Zoom, so I'm really glad that everybody was able to join us. It's nice to see you all. And so today we're going to talk about more about the management structure side of things, but Sandy had a question about that he wanted to pose to the group, but one of the questions that's come up in one of the other work groups that is actually really important for a lot of our clients. So I'll turn it over to Sandy for that.
Hi, everyone. So I don't know if some of you may be on other bar listservs that are that you may or may not be, involving a couple other Oregon Law Commission projects that we're trying to do to respond to the crisis. One that and Ruth is here today from Secretary of State, has been very deeply involved, is we are trying to get remote online notarization approved in Oregon. We actually had a bill through the commission, which was ready to go for the 2020 session. We all know what happened in the 2020 session, but the bill is ready to go. We've had subsequent meetings, and we have a bill that is actually, if you look at the text of the draft overall emergency bill that is supposed to be presented whenever the legislature does meet, on page 27 of that bill is actually our bill for remote online notarization. So if the legislature meets, it is something that the legislature will take up and hopefully will approve. As you all likely have been following, the legislature has not met yet. We don't know when they're going to meet. So there's a consideration that is, and we're actually discussing at another emergency meeting that group is having this afternoon, to potentially pose it as an executive order. And one thing that would be really helpful for us in our conversations with the governor's office and with the commission leadership is, from firms that you represent, are you all hearing that the lack of the ability to do notarizations during this crisis is an issue, is something that your clients, that your firm are finding are getting in the way of parts of your business? I'm just curious.
I've already personally run into it. So yes.
Okay.
Yeah, I would agree. In fact, my wife and I refinanced our house yesterday, which involved a mobile notary coming to our house on Friday with gloves, a mask, a card table that she set up in the driveway with a bunch of paper, and it was very awkward. She brought fresh pens and didn't take them with her, and anyway, it would have been significantly more convenient to do something online. And I even explored, is there any way I can do it with someone from my office who knows me personally, and the signature blocks were on the same pages, so it didn't work very easily. Anyway, I vote yes.
Okay. Anybody else? I'm trying to get, if there's a consensus that we have this group of business lawyers who are also interested in it. It just, as many people as we can show who are having specific issues will be helpful in a message that, if we decide to go to the route of an executive order, we're going to write a letter to the governor's office, and that would be something we would include.
Yeah, Sandy, I would say that, what we talked about before, the estate planning side of things is very difficult right now. A lot of people are concerned about dying for good reasons.
Yes.
But, so that has additional issues beyond the notarization of trusts and powers of attorneys and things like that. But, our real estate folks are really just dying without the ability to close deals. So, I think it's really important that we deal with that side of things.
Great, thank you.
Yeah, I have a friend who had lost his job before coronavirus, got laid off, and then he just got a new job at a tech company here in town. And of course, tech is all totally, remote and everything, but he needed to do the Form I-9. And he was having a hard time finding a notary. And so the employer told him, well, just go find some attorney to, look at your driver license, etc. And so he called me and came over to my house, and I played that role. So, there's all kinds of scenarios that other people have described as well, that would be very helpful to have a better notary system.
Yeah.
Andy, I know with the Form IDs that we file with the SEC, I've actually advised people to do online notaries, and the SEC has been accepting them time and time again. And we've been doing that for a year and a half, 2 years.
Okay. Cliff, that's great to know. Anybody else? I think I got a pretty good sense. We were just looking for as many parts of the bar who are interested in this. You know, we feel pretty good about our work we're doing, and that we have support to get it passed. But we just want to make sure that that everyone is.
Sandy, would it
keeping
be
us sourced. Yes.
helpful for me to send something out to the business law section about this again? Because
It couldn't hurt.
We did have a lot of interest when I sent the first thing out.
Yeah, Ruth from Secretary of State. Ruth is actually joining us today from Secretary of State. Would you think that would be helpful for the business bar to be involved?
Absolutely, it would be.
Okay.
I think if the faster you can get a response, the better.
I mean, our goal is to have something today. I mean, we're meeting this afternoon, and then we can start those processes. Yes, Susan Gravy, I see you.
Hi. I think I just wanted to weigh in on providing feedback to the governor's office from the business law section or from another group. I think it's a great idea. I would really prefer it come through me, if you will, Sandy, simply because we have this each thing, and if you want to do it individually, then you overwhelm the governor's office, frankly.
Right.
And that's not as helpful to them since everybody's slammed right now. So if you've got feedback, Valerie, you're going to ask them to do it. I'll send you the PubAF box and you can send it there and we can collate the responses and get it to the governor's office. We have an incredibly fast turnaround at our shop. So we can do that.
Box?
I'll send you the link. I can't remember if it's PubAF or pubaffairs.org.
Okay.
I'll send you it shortly, Valerie. But it just makes it easier for everybody because we're all working as fast as we can.
Yeah.
And getting feedback is awesome. Getting overwhelmed by feedback is not as helpful.
Yeah, no, I'm going to send an email while we're doing this. So if you'll send that to me, that'd be great.
I'll get it to you in just a
Susan, would you be willing to copy me on anything that you send to the governor's office just so that we're aware?
Certainly, I'm happy to do that, Ruth. But again, if it's coming from the business law section, it needs to be coordinated through us, and we're happy to do that, and we can do it quickly. I would copy probably Sandy, Ruth, if you make sure I get your contact info and send it to Sandy, you, and Valerie.
Yeah, that'd be great. And Susan, actually, if you could copy PK Wrinkles Pearson also.
Sure.
Thanks. Great. So thank you all. I think we have a good consensus that I can share that message that the LLC, our group, is in favor, and hopefully we can see some action on that soon. Really quick before we get started, I saw someone turn over the phone. Who is it? Whoever joined over the phone, it's a 971 number. Can you just identify?
This is Jamie Weddle with the Corporation Division.
Hi, Jamie. Thank you for joining us.
Hi. Yes.
So with that, Valerie, I think we can move forward with our regular agenda.
Yeah. So we don't have all that much of an agenda. I'm going to turn it over to Cliff, who's going to be leading our discussion today on the relations. We're working on Article 4 now. And what Cliff and Mosen had recommended was that we start with 407, I believe, because that gives us the overview of the management of the limited liability company. So with that, we'll turn it over to Cliff, and I'll mute myself.
Well, and I'm going to apologize in advance if you guys hear a big dog barking. If somebody comes to the door, he's going to bark, and there's really no way to shut him up. So with that, I'm going to jump into 407, which I think, Michael, you may have already covered early on during some of our first meeting. But
I think we touched upon it tangentially, Cliff, but not a deep dive.
Okay. Yeah. Well, the current Section 407 from ROCA is very similar and is consistent with ORS 63-130, dealing with management of member-managed LLCs and manager-managed LLCs. It provides for the default to be a member-managed LLC, which is consistent with Washington, Delaware, and our own ORS. The only way to overcome that default for subsection A1 is to provide in the articles of organization that the entity will be managed. Again, consistent with ORS 63-130. Moving down to section B, the member managed LLC. It provides that there will be, that each member will have equal rights in the management, again, consistent with other acts as well as our act. Moving down to B3, where it talks about in a member managed LLC, differences arising among members as to ordinary course matters may be decided by a majority of members. Now, this is consistent with the current ORS. It's consistent with Washington. Actually, it's been a section that I have personally struggled with over the years, just because I've had some clients that have come in and they've had 2 members, one member with 90% control, the other member with 2, but the LLC agreement that they had did not specify how differences would be divided, just how profits and losses would be. So the 90% member would be, it was essentially hamstrung by the other member, because to get a majority, they needed unanimous consent. I spoke to Brian Todd yesterday, who is, as we know, on the Washington Commission that adopted this. And he said they actually struggled with this as well, because the former section that addressed this kind of followed Delaware's current act, which provides for management in proportion to the percentage of profits. And in talking through that, Washington basically thought that that was too difficult, because they had a bunch of tax lawyers in the room and they started trying to figure out what profits meant and how that would be allocated. So they decided to switch over to something that is now consistent with our current ORS and RULCA, which is a majority of the members. So, and I guess one other point there, one of the problems I was thinking about is that if you did have 2 members and somebody wanted to have more control than the other, they could transfer interest to a sister, a brother, a spouse, and so they could then outnumber the sole member. But just keeping in mind that under the default rules, you require unanimous consent before admitting a new member. So that can address that concern. Moving on to B4, affirmative vote or consent of all the members is required to undertake any action outside the ordinary course of activities. Now, this is a new addition to our current statutes, and frankly, it could be problematic, because you have to wonder at what point something is ordinary course as opposed to outside the ordinary course. Again, it is not part of the current ORS. There is in the Washington statute, they have an ordinary course standard like this. But Sandy, I'm kind of just continuing on. I didn't know if we wanted any discussion on these points.
Yeah, sorry, I didn't, I think the way, a couple ways that you can chime in is if everyone stays just universally on mute, other than the person who's presenting, if you want to speak, if we do that and the person who wants to speak just takes himself off mute briefly and then speaks, it will actually work quite well. The other thing you could do is type a chat to everyone on the during the chat feature and present whatever topic you want to discuss. So either way is fine. But Cliff, thanks for prompting me there. But with this small of a group, with 15, I mean, it's not small. Oh, the other thing is, if you haven't used Zoom a lot and you want to see everybody, click the speaker view on the top right of your screen. Then you'll see everyone instead of just the speaker. If you want to see just the speaker, whoever's making the most sound, then you can keep it with the gallery view, or the presenter view. But yeah, click one of those 2 things.
Everybody knows how to find the chat windows.
And you can also,
yeah, go ahead.
Sorry, dog.
No, go ahead and explain.
Oh, yeah. So chat window is on the bottom of the screen. If you just click on it, it'll pop up. You can chat to everyone, or you can also chat to individual members. But yeah, the one thing is if everyone would stay on mute, otherwise, unless you're speaking, it would help the whole process.
So Cliff, can you talk about, and I haven't looked through it, so I assume you have, why this was added to the Uniform Act? You say it was new?
Well, it's not, I don't know that it's new to Uniform Act. It would be new to the ORAs.
Okay.
Meaning we don't have that, but again, it was, there are other states that have adopted this standard for unanimous consent. And given that this is the default rule as opposed to more of just a mandatory requirement, we would look to the operator. Hopefully the attorney would address that.
Yeah. Okay. Thanks.
So
if just a question, I don't think outside the ordinary course is defined in the statute, but I don't see it in the main definition section, but did you see a definition for that anywhere?
I did not, and there is kind of some commentary about that as to, that frankly, it is something that, could be a challenge for people and lead to controversy.
Do you know if any
members.
Do you know if any of the states have a definition of ordinary course?
I don't. But I think that maybe there may be case law on it. I have not looked that far.
I'm sure there's case law in ordinary course because it comes up in bankruptcy all the time. But my question is this something that can be varied by the operating agreement? Because if you're talking about an LLC with 3 members, this is probably practical. If you're talking about an LLC with 47 members, you're never going to be able to do anything.
Absolutely. These are the default rules, and again, the operating agreement would trump it.
I would just add on to Teresa's point. I mean, this and other sections like it, you have to always go back to section 105, and the general rule under 105 is the operating agreement is primary in establishing the relations inter se with the limited liability company and its members, et cetera, unless we get into an area where 105 says we can't vary the statute in certain specified areas in 105 C and D. And so I think under this section, if you had a well-drafted operating agreement that defined ordinary course for purposes of these kinds of issues, certainly I think that the drafter could do that.
Correct. And that CMO is also, addressing the commentary to the rule, but I agree entirely. And so last time we did, actually going back, were there any questions or concerns about majority of members in subsection 3 above? Is there any desire to look at the Delaware statute, which provides for governance and percentage to the allocation of profits?
This is Ruth. So I was thinking this morning about, upon adoption of this act, then all of the LLCs that are already in existence are going to have to conform to the act. Mm-hmm. And so if we have LLCs, and I know that we do, that specify a percentage of ownership in their operating agreement, my guess is this is going to be an issue for them.
Well, and speaking as the tax lawyer, one of the tax lawyers in the room, I think that it might be problematic to talk about profits, because that's a definition that's may not be a problem in a lot of operating agreements, but may very well be a problem in some with respect to the tax allocations, that they may not want to follow the tax allocations in terms of their governance.
I guess I would add to that, if you have an operating agreement that specifies that voting shall be based on you know, it is typically based around profits, but maybe some standard defined in the operating agreement, then that's going to control over this provision. So what we, you know, what this does is if there's just, let's say there's no operating agreement at all, you know, our two carpet layers that file articles with the state and they do nothing else, this in effect becomes their operating agreement. And I think down in that context, I think our colleague in Washington, they ran into the issue of just the proof problem of for those guys determining what profits are, because if they contribute different amounts of capital, but it's unclear based on their interaction whether that is also the basis for their profit sharing, then, you know, I think it's a very difficult issue. I mean, you know, you're going to litigate that probably, but it's a difficult issue to determine. And again, I think look at these provisions as gap fillers, and if there's an adequate operating agreement that specifies how voting is weighted, that's going to supersede this.
Well, and that's another option, Michael, is to have it based on percentage of contributions, which I'm not necessarily advocating for, but at least that's something that is not that's not impacted particularly by tax allocations in the operating agreement.
And Brian actually mentioned that specifically is being discussed in the Washington Commission, and they thought it would get too confusing with book up events and other events. So what they ended up doing is just coming down to saying, you know, the simplest, least controversial way is just to go by members, even though this could be problematic, but knowing that it's the default rule and it can be trumped by the operating agreement. It's where they ended up. Not sure why Delaware has continued to go the profits route. So it sounds like there's consensus to move ahead with the majority of the members. We'll go there, and then obviously going through subsection 4, the unanimous items requiring unanimous consent. One of the items that when we discussed this last time that we had added is a subsection C under amend the operating agreement. We had wanted to add or is otherwise required by the act, because there's other sections that require unanimous consent. And although it's not stated there, it's something that the group had thought was a good thing to add there.
And sorry, Cliff, can you remind me where you are? I'm looking for it.
Yeah, so in subsection B4, where we talk to the affirmative vote of essentially all of the members.
Yeah.
You've got AB, where it's first is undertaken action outside the ordinary course of business. The second one is amend the operating agreement. And the last time we went through this, my recollection is that we had added a subsection C to be as otherwise required by the act. You let people know, put them on notice, there are other sections in the act that require unanimous consent, such as admitting a new member.
Oh, I see. So move the or to B and then add C.
Exactly.
Otherwise, yeah, I don't have that in my notes, but I think it's probably a good idea. Anyone have any objections? Okay.
Okay. So, and again, the pretty much everything we've discussed so far is consistent with ORS 63-130, nearly word for word, except for that, like the ordinary course, which was an addition. That section for unanimous consent, keep in mind, again, it's not exhaustive. And so we're adding that one section to cover it. In a manager-managed LLC, where we're getting to subsection C, it's consistent in section C1 with the current Act, which provides for a majority of managers if there is more than one manager. The commentary notes that there is no definition of a majority of the managers, and there could be a problem if you have like a board that is the size of 5, but you have 2 vacancies. That would then require unanimous approval of the existing members, depending on your interpretation of that. But again, this seems consistent with other states. I don't have a concern with it. Move on.
So, Cliff, just for my housekeeping, do we know what's the parallel ORS that we're looking at?
63-130, and this is specifically subsection 2B.
Okay. 63-132. Sorry, I should have asked that sooner. Okay. Okay, sorry.
Yep. And then the next one, each manager has equal rights in the management and conduct of the company's activities, similar to section 2A of 63-130. Again, it's consistent. Subsection 3, this is similar to the unanimous vote of the members. So you still have unanimous consent of the members required to undertake actions outside the ordinary course, amend the operating agreement, or if we are going to add what we had thought we would add last time, we'd add C as otherwise required by the act.
Have we made any decision on the ordinary course? On whether we want to keep that or not?
I haven't heard any objection to it.
So, I mean, I think it makes sense, Roberta, doesn't it? Now, Teresa, if you want to weigh in, because we do have this language come up other places in the statutes.
Yeah, I mean, it ends up being one of those things that a judge decides after the fact in a closed case, but most questions really are pretty obviously ordinary. Are you, paying for your routine inventory? That's going to be ordinary. Are you getting a new bank loan for $10 million to expand? That's going to clearly be non-ordinary. If you're getting a inventory loan, is that going to be ordinary or non-ordinary? Well, your bank is going to tell you they want everybody to sign anyway. So
okay, so it's along those lines. But I know that some LLC agreements are very broad in their definition of what business the LLC can engage in, and others are not so broad. And then you have the situation that comes up where there's no agreement at all, and so But I guess I don't know. I'm not a practicing lawyer, so I don't know how often this might come up in litigation or not, or whether that would be burdensome.
Yeah, ordinary course of business gets litigated a lot in bankruptcy because certain payments can be clawed back unless they were made in the ordinary course of business. So there's a pretty well-established body of case law on that subject. It's been my experience that whatever the operating agreement says the company can do, if it says it can engage in any lawful business in the state of Oregon, which is what many of them say, has absolutely no bearing whatsoever on that. It's actually looking at what the company does in its ordinary day-to-day, getting into the nitty-gritty facts and circumstances of what's typical for this company to do, which means it can sometimes be expensive litigation. But, if this company bought, 10,000 units of inventory every month for the last 36 months, buying another 10,000 units of inventory is going to be considered ordinary. But you look at that by having somebody testify about the fact that they bought 10,000 units of inventory this month, every month for the last 36 months. It's not hard to prove. It can just be kind of tedious to prove.
And at that point, if there are members that are, at odds with each other, they can always look at things differently.
And they do. And that's why whenever somebody's voluntarily entering into a transaction that might even come close to non-ordinary, they will typically ask for corporate authority for it. And I most typically see that in connection with bank loans. or amendments to bank loans, to be more specific. They just get everybody to agree to it before they do
Well, and
it.
I think if you look at the chat, Kathy has a good point where she says the commentary to C3 says it's not an exhaustive list of situations. So
yeah.
Well, yeah, but that's specific to items like looking to 401c3 where you're admitting a new member requires unanimous consent. I don't know that that's going to the ordinary course.
Right. Yeah, I think that's fair. Okay. Any additional discussion?
Yeah. Are we fine moving on, or do we want to leave the ordinary course?
I think we're fine for now. If we need to come back to it, we can.
Okay. And Roberta, I do share your concerns with it, which is one of the reasons I wanted to flag it. Not necessarily a fan, but again, keeping in mind that it's the default rules, most operating agreements that I see, at least that are prepared by reputable counsel, set forth the actions that require member consent.
Right, and I'm fine with it too. It's just I heard it raised and then I didn't catch whether it had been resolved or not.
Yeah, no, appreciate it. Okay, moving on. Valerie, did we want to add that, or is otherwise required by the Act, to this unanimous vote of the members in C3?
C3, yeah, I've got that in my notes, and I didn't hear any strong objections from anybody else. So hearing that,
I have it as consensus as well, Chris.
Yeah.
Cool. Okay. So subsection 4, manager may be chosen at any time by the vote or consent of the majority of the members. Again, I don't see anything controversial about that. Same thing with removal. Again, keeping in mind just your default rules. I actually think they're proper and they're consistent with other acts, which I'm a fan of. Subsection 5, a person need not be a member to be a manager. Yeah, seems consistent. People can bring in professional managers.
Do we know what it means when it says, in the case of a manager that's not an individual, terminates?
So if it's an entity that's, for example, I just said if you have a professional manager, you can appoint an entity that's a manager.
Right, but what does it mean to have that entity terminate? Does that mean that it decides it's not the manager anymore? Or does that mean that that company dissolves? Or does that mean that that company has been put in bankruptcy and now there's a bankruptcy trustee in charge of that former manager? I guess I don't understand under what circumstances a manager terminates.
Well, the context I see it in, where you have an entity manager, is in private fund work.
Okay.
Where you've got an investment manager who manages the fund. And so if that manager, there's a management agreement between the fund and the fund manager, and the fund manager has the right to unilaterally terminate that management agreement, thereby resigning as a manager.
Okay, so it's the contractual relationship to be a manager as opposed to something happens to the management entity itself.
That's the way I envisioned it. I'm sure there are other ways. You mentioned if an entity is bankrupt.
The East Coast, yeah, it's like a power tussle, right? He was like, I'm in charge of the East.
I'm sorry, I didn't catch that.
Yeah, who?
Sorry, guys. My wife's on a call as well. We've got the law office of Hein and Hein here in the attic. I was just coming off mute to note. I was just coming off mute to note. I think there is a reference to termination in the official commentary referencing subsection C4, and I do think it's talking about just an entity actually ceasing its existence. It seems to be what they're referencing there. It's the top of page 104.
And also, if you're checking the chat, Kathy also agreed with what James just said. So just if you're able to keep an eye on the chat, people are putting good commentary in there.
Very good. Okay. We're into subsection C6. A person ceasing to be a manager does not discharge any debt, obligation, or other liability. to the LLC, which the person incurred while a manager. So, again, it's just maintaining the legality of that obligation. I don't have any concerns with it. Moving to subsection D, an action requiring the vote or consent of the members under the act may be taken without a meeting, allowing for somebody to appoint a proxy agent or consent or otherwise act for the member by signing in an appointing record personally or by the member's agent. Again, I don't find anything for the rest of this controversial. Dissolution of an LLC does not affect the applicability of the section. Not necessarily certain why that is added, but it's part of it, and again, not controversial. Subsection F, an LLC shall reimburse a member for an advance to the company beyond the amount of the capital the member agreed to contribute. This just goes to, again, people who make additional or make excess capital contributions than what was agreed to get a refund. And any excess or advance payment in section G, they're stating it constitutes a loan from the company which accrues interest from the date of the payment or advance. Again, not a problem. H, this is not covered in the ORS currently, or even looking at Washington, it's not here. A member is not entitled to remuneration for services performed for the member managed LLC, except for reasonable compensation for services rendered in winding up the activities of the company. So if a member, the way I read this, if a member helps to wind up the company, then they would be entitled to reasonable compensation. Again, this is not in the ORS. It's not, when I look through Washington statutes, it was not there. I'm frankly uncertain why this is added or even needed. I don't know if anyone has any comments on it.
Cliff, can I go back and ask a question about G? I don't think, just making note, but I want to ask the question, that payment or advanced concept in the interest, there's no counterpart in ORS to my recollection there, but did you find anything that parallels the ORS to that section G?
No.
Okay, so yeah, I think worth noting that's a new concept.
Well, and does anybody else want to add at the applicable federal rate after the word interest? Or at some agreed upon rate or some sort of statutory rate of interest?
Well, under Oregon law, it would be deemed to be the 9% state statutory rate if it's not stated, but it probably wouldn't hurt to actually say that.
Yeah.
And maybe even cross-reference the interest provision in ORS.
Yeah, I mean, that was my presumption, Teresa, that we look to the statutory rate of interest to fill in the blank in terms of what the interest rate is.
Yeah, I would share that assumption that the statute or state statutory rate would apply, but would lean toward leaving the ROLCA language as it is. Just in general, you know, for example, I'm fine adding that C about or is otherwise required by the Act, where affirmative consent of all members is required. But in general, I lean toward not having so many different provisions pointing to other places. There's, I think, a lot of points in the ORS where interest is referred to without each instance pointing toward the statutory interest statute.
Okay, so that's maybe a question for our drafter then, Sandy. Just to ask if he wants some sort of cross-reference, because as long as everybody in the room understands what that number is, I think we're fine. But
I think most have come to the conclusion that in interest here we would go to the statutory rate of interest. Might be worth mentioning that in the commentary that's the intent of the committee, that you know we would look to the statutory rate of interest to fill in that blank.
Actually, I just pulled up ORS 82.010, which is the legal rate of interest, and it lists what transactions that applies to. And I'm seeing, not sure, because this is referring to contracts, monies received to the use of another and retained beyond a reasonable time without the owner's express or implied consent, judgments. I'm not sure that it actually technically applies, but I think we should cross-reference it so it will apply, because I think that would be our intent, to have the statutory gap filling rate apply, unless for whatever reason the operating agreement provided for something different. Otherwise, you have to amend ORS 82.010 to cross-reference to this. So I think we've got to mention it somewhere, or it doesn't happen automatically.
You don't think it would fall into 0101A, Teresa? Seems pretty broad.
Well, and I think Ruth's
Maybe.
comment is well taken, that I prefer to see a interest statutory reference so that people who are not in the room understand what would apply, which is fair. So we can talk with Legislative Counsel's office about whether it's more appropriate to have it in the statute itself or have it in the commentary.
Yeah, Valerie, I'm making notes to both send it to the drafter and also put for the commentary.
Okay.
Yeah, I mean, maybe 82010A would apply. I can see where you get that.
I also had some other thoughts about this ROLCA section 407 and how it relates to current 63-130 and a couple other provisions, primarily with regard to ORS provisions that are not in the ROLCA statute. But I can wait on that, Cliff, if you're still presenting, or whatever your flow is.
I can feel free to jump in.
Okay. One thing I noticed is regarding the ability to do proxies in section D. It says a member may appoint a proxy or other agent to vote. And then when I look at ORS 63-136, it says that a member or manager may appoint a proxy. And it seems to me ROLCA doesn't allow managers to do proxies, at least not in its default rules. And I didn't know, it apparently is an intentional decision by the ROLCA drafters, but I think it's a difference in the default rule compared to what we currently have in Oregon. I thought we should at least note it and decide whether we like that change.
Cody, I guess I like that call out. I actually like the current statutory inclusion of manager. I think that would be a good add.
And I didn't see anything in the ROLCA commentary explaining why they would allow members but not managers to do things by proxy. I'm not sure if there's a good policy reason to just differentiate them.
So it could be akin to a corporation where the shareholder has the right to give a proxy, but a director would not, because maybe a manager is more like a director. That would be one thought. I guess I would favor not letting the managers give proxies, because it sort of goes against what they're actually trying to do.
They should be more hands-on.
Right.
Okay.
And that may be the reason why the drafters of this uniform statute did that, but you're right, the commentary doesn't say anything.
So, yeah, should we leave it? Should we leave ROLCA as it is then? I mean, I'm fine either way on this.
I mean, I think my preference is generally to leave it as is for the reason that David noted. We can flag it, and if we think it's an issue as we go through this, then we can circle back to it.
And I think there's something in the commentary, if I'm looking at the right place, page 104. And this is D we're talking about, right?
Yeah.
And it does cite to the restatement of contracts.
No, it's,
Isn't it D that we're looking at?
yeah, D.
So I don't know exactly why they're citing that, but they're saying a promise requires performance by a particular person to the extent the obligee has a substantial interest in having that person perform or control the acts promised. And I don't know if that goes to the comment that directors of corporations can't have proxies because that's their role to be more involved. And is there a parallel to that to managers in an LLC?
I read the commentary to primarily want to prevent people from using proxies to avoid the restrictions on transferring your LLC membership interest, to essentially bring in, oh, this is my proxy, so now they're like the member and get all the rights and all that, and I'm kind of bowing out as a member, and now you have a new member, essentially, who is my proxy. Or at least that seems to be the only example
Well,
we give.
Yeah.
I mean, people can fix this or change it by their operating agreements. And also typically the managers can delegate as between themselves for specific actions and areas of authority. So, maybe we don't want to we want to just stick with the basic framework that's in the act right now.
Just to add on to that, Valerie, even looking at Delaware's Limited Liability Company Act, it just provides members with the right, and does not provide managers the right to appoint a proxy. I think David's reasoning and rationale was like somewhat compelling.
Okay.
And then another one I noticed was 63-130, section 4. Is a huge section that says, unless otherwise provided, by the parties' agreement, in a member or manager managed LLC, you need a majority of the members to consent to whole 10 different things that they list out. Anyway, it strikes me that the ROLCA is a change from a lot of that, which I think is all fine, but I thought at least we should know that, at least as to those 10 scenarios, or most of them, this would be a change in the law.
Yeah, I don't have anything to add on, okay?
And then also subsection 7 of 63-130 is, I didn't find a companion to it in 407 or otherwise in chapter 4 of the
subsection 7.
Yeah, unless the context clearly requires otherwise, references in this chapter to managers apply both to managers of a manager managed LLC and members of a member managed one. I don't think we need that in the way that ROLCA is written. And then also there are some provisions in 63-441 regarding a manager's ability to amend the articles of organization to change the corporate name, the company's name, and take some other actions that are not in ROLCA. And I'm fine with the ROLCA version, but I thought we should note the change. I don't know if others agree that we should just adopt ROLCA and let that ORS die. And then also 63.444 has two sentences, and the second sentence is not in ROLCA. Unless otherwise provided in the Articles of Organization or Operating Agreement, the managers of the LLC may but need not propose or take a position recommending or disapproving any amendment of the operating agreement. And to me, that's just sort of like a meaningless sentence, but it's currently in the law, and it would not be in ROLCA.
You know, I think with respect to 63.441, we ought to put something in the commentary that says something along the lines of, we didn't think we needed to spell this out specifically anymore because you can still do this under the new act. By not incorporating 63.441, we're not saying that we are intending to change the law of 63.441. We just don't think it's necessary anymore. Because you will have somebody who will argue later that, well, you got rid of that statute. You must have intended to not allow that to happen. And I don't think that's what we're doing. I think commentary is the place to address that, though, rather than some kind of a change in the statute or ROLCA.
I didn't put like 444 in this section because I was considering it to be kind of a mirror of 202 of ROLCA.
Right, but there's a lot of provisions in 63.431 to 444 that are not in section 202 of ROLCA, and sort of, I mean, like 441, it's sort of, you know, directly talking about who can make the amendment, not just how is that amendment made generally.
Right, but you know, you look at those amendments and they're largely ministerial, right?
Mm-hmm.
Right. I can't remember what 202 says about who can amend the Articles of Organization.
The 202 starts on page 58 of my printout. Yeah, it basically says that if it's inaccurate, if you look at D on page 59, a member or manager shall promptly cause the certificate to be amended and then deliver it to the Secretary of State for filing.
So it seems like a manager could amend the certificate of organization just on their own. They wouldn't need any kind of vote of the members.
Well, member. Yeah, if it's inaccurate at the time.
No, or even just under 202A, they can do it at any time, whether accurate or inaccurate. They can just change it.
I don't think that's correct.
No?
I think looking at that sub D in 202, it's worth noting that the information can be changed if it's inaccurate when the certificate is filed or has become inaccurate due to changed circumstances.
Yeah, but not just because they feel like it and it's Tuesday. I mean.
Right. Well, I think there, but the point is you look at 63.441 and the sort of the ministerial elements there relate to correcting names and addresses and that sort of thing. There's probably not an exact counterpart to 441 sub 4, but I view that as very limited relating to the LLC monikers that might occur on the LLC's name. But I think there's some parallel with 441 and this section that if information becomes inaccurate, people change addresses, for example, I think the manager has the ability to make that correction.
In my recollection, when we covered that, it was more to address if, for example, the registered agent was listed in the articles, then the manager could change the registered agent. So it was, to Valerie's point, more administerial matters. Valerie, I don't know if we want to spend more time on these sections 63, 441, 444, or continue with 407.
I think we've talked about 441. I'm just sitting here flipping through them. At 431, we've talked about essentially with respect to Article 2. We talked about amendment just now. I mean, I think we can move on unless anybody has any strong objections.
I agree.
Okay.
I'm going to sign off, everyone. I've got to jump on another call, but I'll circle back around with both Valerie and Sandy, okay? Thank you.
Not going anywhere.
Okay.
Okay.
Thanks, Susan. We appreciate it.
Thanks.
I'll hear from someone. Thank you.
So, okay, we're in a subsection H of 407. Again, it's talking about remuneration for services performed for the limited liability company. A member, note that it's a member only, not a manager, is entitled to reasonable compensation for services and winding up the activities of the company. The commentary notes that a manager may otherwise be and have a common law right to compensation in winding up the company. I was unable to find a corollary in the current ORS or even Delaware or Washington that provided for a member to actually be compensated for services connected to winding up the affairs of the company. Didn't know if it's something we wanted to keep in there. I know we've kind of taken the position that unless we have a strong preference not to include it, we will include it for consistency purposes, but was wondering about the group's thought on that point. Or not.
So as a tax lawyer in the room, one of the tax lawyers in the room, my feeling is that a lot of this would be addressed in the economic deal provisions. So to the extent that there's some sort of guaranteed payments or things coming out, you know, that's where you'd see remuneration in a member managed entity. But does anybody else have any other thoughts about, you know, if we should keep this or not?
I don't have strong feelings on it.
I think it's probably a good idea to keep it because when you're winding up in a company that doesn't have enough money to pay all of its obligations, somebody has to do the work to figure out where the stuff is, to tell the bankruptcy trustee where it's at, and to do schedules or whatever might need to be done. And if nobody's willing to do that because they're not getting paid, then it really is going to be inefficient for creditors to get paid what they should. So I'm inclined to leave it in.
I vote to leave it in too.
I'm fine leaving it in. I'm also curious as to those people who are drafting operating agreements. I've never seen an operating agreement that provided for compensation for a member or manager and winding up a company, and was curious if anyone else has.
I haven't seen it in the operating agreement, but we have seen it in practice where they'll agree that, okay, you know, we're as part of the liquidation documents, so-and-so will be taking care of these things. So.
Yeah, to that point, I'm just kind of leaving it to everybody to agree on.
I love seeing everybody's pets, by the way.
Okay.
I think we can move on. I think it's fine.
Okay, sounds good. Moving on to 408. We're good? Okay. 408 deals with reimbursement, indemnification, and advancement, also insurance. It is a kind of the corollary is currently ORS 63160. It is very close to 63160, except that ORS 160 or 63160 provides for possible indemnification or permissive indemnification, whereas RULCA provides for mandatory indemnification of members and managers of an LLC. It does not extend to officers, but again, it's a big change in that it is now mandatory indemnification for members and managers of the LLC, subject to certain exceptions set forth in section 405, 407, and 409, which are very similar to the carve-outs in 63160.
I think Secretary of State's office may want to weigh in, because this will require a change to the form probably, because it'll be an opt-out rather than a opt-in on the indemnification.
That's a pretty simple change for us to make, so it's not really critical. And frankly, indemnification is one of those areas where sort of unsophisticated folks that are starting a business without the help of an attorney or tax professional of some sort are always asking questions about those optional provisions that are listed on our form.
Mm-hmm.
And to make it an opt-out makes it a whole lot easier for us.
Good.
Okay. Again, that's well, that's kind of the first two. Again, if you look at the commentary, it talks about if an LLC wants to provide for indemnification of officers, which, because it's not covered in the statute, they can do that in the operating agreement. Subsection C goes to advances, and instead of going to mandatory advances, it provides for permissive advances of indemnification fees for a member or manager. Again, which is actually consistent with 63160. D is new. It's not covered in our current ORS. It provides that an LLC may purchase and maintain insurance on behalf of a member or manager against liability. I don't frankly understand why that's necessary in such a permissive section. That was, yeah, any thoughts on that language? And the commentary talks about the language being just very broad for and defer to the company to make those choices. So it's truly just providing that option in statutory form.
I don't think it hurts anything. I mean, because it basically is just saying if you want D&O insurance, you can get D&O insurance.
Yeah.
And it doesn't require anybody to do anything. So I don't have a problem leaving it in. Is there any, I mean, should we reach out to the insurance folks? I'm sure the insurance folks will like this, but.
Absolutely. So, again, I don't have any concern with it. The one place that this really does differ from the current ORS is ORS 63784 requires an LLC to report any indemnification of a member or manager to its members. That's not in section 408. So I didn't know if we wanted to add that to 408. I actually think it's I could be persuaded the other way, but I actually like ORS 63784 for that.
I like 784 a lot, especially when it is shifted to a mandatory construct, where in particular, this is sort of the default rule, and people who aren't gonna see a checkbox even on the Secretary of State form, or otherwise they aren't thinking about this kind of a thing, and then the first time it would arise, all of a sudden there's been all this indemnification going on, and they won't have a reason necessarily to know about it. Plus, I don't think it harms the company in any way to give the notice.
It provides for more transparency.
Right.
Added 74, and it's literally a one-line item, a one-line addition. Any other thoughts? Michael, you've been pretty quiet lately.
Gonna unmute here. I would be fine adding 784 to this section. I could make the argument that the absence of a report could be a breach of fiduciary duty even without this provision, that particularly in a manager-managed LLC, not not reporting to the members of the nature of this sort of extraordinary action in any way, really hiding the ball. I think an argument could be made that that's a breach of duty. I think if anything, this is instructive to LLCs and their managers and members that generally this is a pretty extraordinary event, and why wouldn't you want to report it? And if it's not reported, why not? And so I don't know much of the history on 784. It frankly doesn't come up a ton, but I think there's a good argument. If nothing else, it's instructive to the LLC management that if you do this, you do need to report to the members.
James, I'm sorry, as you take some coffee, did you want to comment? I see you put a thing in the chat box here.
I just wonder why this type of expense is different from others. I know it is extraordinary, but LLCs have lots of different extraordinary expenses. And I worry that this could turn into a claim. I mean, if the LLC doesn't inform other members, do the other members now have a claim against, I guess, the manager for failing to report? It just seems to set up an odd result in my perspective. And again, my default is always to default to RULCA where we can. I just don't see the value here, but that's just my.
Has anyone ever seen this come up directly, litigated it? I have not specifically.
I haven't litigated it, but in these kinds of disputes, and I would think that these are different types of scenarios. It's not an unusual expense in the sense of the company is going into a new line of business or making a purchase that they don't normally make, but that's business related. This is always it's going to be related to an accusation that somebody involved in management, or whether as a manager or as a member, has done something wrong that harms almost always in other internal people, or at least some external person, in the way that they are doing their management of the LLC. And so I think that's the kind of thing where, you're humming along, your manager is doing whatever they're doing, as long as it's for operating the business or doing the regular type things, even outside the ordinary course type things, so long as it's not relating to liability, like you're running the business poorly in a way that is violating your duties. And that's something where I think, whoa, you know, stop the presses. I think other members want to know what is going on. And all of a sudden we're advancing expenses now because there's been some kind of, you had to incur expense. It means someone has said you are violating your duties as a business operator. And to me, that's something that people ought to, that's not just even a typical outside the ordinary course, that's really extraordinary. And I think it's something that other people who are relying on, you know, the person who's having expenses advanced for them to operate in good faith and so forth, all of a sudden that has been called into question. And so I think that it makes sense that they would want to be advised about that. And in terms of whether,
to me, I guess that would,
I don't know.
Yeah, to me, that rationale would suggest that the notice should be provided when the existence of that type of claim is out there, not just, this is pretty specifically tailored to the payment of expenses or the advancement of expenses, the indemnification itself. It's not the allegation of a breach of a duty. But and I hear your point. It's a fair one. I don't feel strongly about this provision.
Yeah, I can say, you know, I'm somewhat on the fence. I think, and James, the point you just made about, you know, if situations arise that maybe necessitate indemnification or an advance, I think transparency and the dissemination of relevant information is one of the hallmarks of fiduciary duties. And the failure to be transparent in that way probably breaches fiduciary duties. So maybe to some extent, 784 adding that in would be redundant because I think there are other elements around these kinds of events even before the actual indemnification or advance that should be disclosed. In my estimation. So maybe it's singling out the event of the actual payment of indemnification or advance, you know, gives an argument that you don't have to report before then.
Cody, can I ask you a litigator's question? 784 only requires this in connection with the proceeding by or in the right of the LLC. So this is a proceeding by the LLC against the manager or member, or in the right of the LLC. What does in the right of the LLC mean?
Derivative actions, which is typically where
breaches of fiduciary duties, or
yeah, that's, let's say you have the you know, I'll just call it the, you know, the bad manager who's running the company and profiteering from it wrongfully, and then you have, let's say, you know, that's your active partner, and then you've got your passive, I just put money into the project partner, and now I realize I'm getting defrauded here, and the company isn't going to do anything about it because the manager is the fraudster, and I'm just a member, an investor, and so I can't stop the fraud myself. I have to bring a derivative action, and the company isn't going to sue the fraudster because the company is controlled by the fraudster. So that's where you get derivative actions.
So I guess going to some of the earlier discussions, some of it was afraid of, James, I think you'd mentioned just some general claims by a third party against the company. It sounds like it's more limited to literally proceedings by the LLC against that member manager or some of these derivative actions, in which case it seems so severe that I think notice to the other LLC members would be appropriate.
Yeah, and good catch. It's not related to third-party claims. That's a good catch.
So Valerie, I don't know if we should have a vote or what have you to see if this 784 should be added.
Yeah, how do we want to do that? You know, I think I'm okay going with the roll call language, but how are people feeling about this? Who wants to have discussion about incorporating 784 language into this?
I guess
I would favor incorporating 784 language. I think it's probably there for a reason. I maybe can't entirely see what that reason is, although I'm hearing lots of good reasons. I can see, looking at the history of the statute, that it wasn't in the original 1993 version. It was clearly amended in 99. So somebody did that for some reason. Maybe because there'd been a circumstance where they hadn't been able to take advantage of a fiduciary duty argument in the way that Michael is describing could happen. But I don't see any harm to adding it, and it strikes me as one of those changes that if we can keep a little bit of the Oregon law and make it a little easier in the transition for people, maybe this is a good place to do that.
Okay. Any thoughts in opposition to that? Okay. So we can make a note then, Sandy, for the drafters to pull in the 784 language here. Okay.
Do we want?
I wasn't able to unmute fast enough.
Okay.
But I was kind of persuaded by the comment, and I'm sorry, I can't remember who it was, that said, well, why should we have notice for this when we don't have notice for a lot of other payments? So that was persuasive to me. I don't have strong feelings, but that seemed to make sense.
Valerie, my question was, do we want to go with the entirety of the language from 784, or is there a section of it that I want to note for the drafters?
Well, 784 is only like one sentence long, so.
Right.
I want the third and fifth word.
Okay, so I put the whole section in the notes. Okay.
Sorry, being a smartack.
Is it possible also, I'm fine adding it again, I'm kind of on the fence. The point that I made before, I wonder if we can add something in the commentary that the committee, the drafters here don't intend that this in any way abrogates a member or managed fiduciary duty of transparency. Something along those lines. You all see what I'm referring to.
I think that's a good suggestion, Michael.
I think if there's claims and events that are important to provide information about, then I don't think this section should be interpreted as allowing a member or manager the ability to wait until they're actually cutting a check for indemnification or advancement to be the first time that there's transparency and disclosure of the matter. And again, I would argue that's one of the hallmarks of fiduciary duty, and we're not intending to in any way abrogate those basic elements of fiduciary duty.
Great.
Yeah, I'm typing it up.
Okay, and just so I'm clear, is everybody fine moving away from permissive indemnification to mandatory indemnification? Doesn't sound like there's any objections to it. Sounds like the Secretary of State is fine with it. I would just note, I guess Washington is permissive to the extent it's we share a state line.
I mean, I'm fine with it. I think it is, it's a significant change, but I think more often than not, there is an operating agreement and people have these provisions in them anyway. Yeah. So I don't know ultimately how many litigated business disputes this is going to alter in terms of indemnification, whether it exists or not. And in terms of what is the default, I think this is a fine default rule.
Okay.
One thing I wanted to call out is there are some differences between this and 160 in the sense that I think there are 3 scenarios under current law that you're not allowed to do indemnification or elimination of liability that this allows you to do that for. And in part, it's references to, other sections of Roll Co, in particular 105 about what you're allowed to eliminate and not. But I thought at least some of these limitations under current law would be good to maintain. For example, in 63-160, you can't eliminate liability for, provide indemnification for any act or omission occurring prior to the date when the provision, I guess, never mind. If you're having mandatory, then the prior to the date doesn't matter. You're always going to have indemnification. Never mind, that was a mistake. And then, but 63-160 subsections 1 and 3, I didn't find a counterpart in ROLCA, which is under 161, you can't indemnify or limit liability for breach of duty of loyalty. But under ROLCA, you could allow for indemnity of that, for that breach of duty. And also for under 63-163, unlawful distributions. Under current law, you can't immunize unlawful distributions, but under ROLCA, you can.
Actually,
I was looking through it. Maybe I'm wrong.
Yeah, Cody, I mean, like section 405 is specifically carved out of indemnification. 405 is the distributions. Illegal, unlawful distributions.
And 409 is standards of conduct as well, Cliff, right? So
yep,
they would have to comply with the standards of conduct. Go ahead.
Came over the top of you, James. It's right on the top of each other, and we'll get to 409.
So just to fix my notes, you're saying 405 has the relevant limitations on distribution, and therefore, if you violate 405 as a member or manager, then you are going to be liable for unlawful distributions, or are you immunized for them?
You can't be indemnified for those.
You can be.
You cannot be. You're carved out of the indemnification.
Oh, okay. So
right, you're indemnified as long as your actions don't arise from a breach of 405, 407, or 409. So you'd be breaching 405 and making an illegal distribution. So you would then not be entitled to indemnification.
Okay.
Yes, that's
and duty of loyalty, to your next question, Cody, duty of loyalty comes up under 409. So if you breached your duty of loyalty under 409, you would not have a right to indemnification.
Yeah.
Okay. And what about so those are, I'm just trying to think also about 105C7. It says the operating agreement may not relieve or exonerate a person from liability for conduct involving bad faith, willful or intentional misconduct, or knowing violation of the law, which I had read to mean that you can relieve or exonerate a person from liability for unlawful distributions or breach of duty of loyalty.
Well, again, duty of loyalty, duty of care, and we'll get to this in 409, but grossly negligent act, reckless conduct, intentional misconduct, violations of law is all in 409.
Okay, so I guess my issue is less with what the default rule is, and ultimately later when we talk about 105C7, which default rules are allowed to be amended by the operating agreement. Like if, as I understand, you're telling me the default rule is liability for all of these unlawful things, from unlawful distributions to breach of the duty of loyalty.
Mm-hmm.
And then, so that's the default rules. You do have liability, just like you do under current Oregon law. And then the next question is can the operating agreement relieve the quote unquote bad actor from that liability. And that is a question addressed in 105, not in these 400 level sections.
Yeah, and I think it's worth putting something in the commentary about this because this is a really important point, obviously. So, you know, having those cross references both within the roll call sections, but then also back to ORS 63-160, I think will make sense here.
Okay, so yeah, I don't have anything to say then insofar as we're talking about section 400 itself.
Okay.
Okay.
Good discussion, though. Thank you very much.
So we good to move on to 409?
Yes, let's do it.
And I have to hop off. Sorry, everyone. I have a call. I have a court hearing actually.
Wow, interesting.
I got to prepare for. But thanks, and I'll check the notes.
Thank you, Cody.
Send out Sandy.
Thanks, Cody. I'm going to be updating those in the next couple of weeks. Thank you.
Okay, section, shall I go ahead? Oh, we're good. Okay, section 409, standards of conduct, mirrors in many respects ORS 63-155 with a similar for the duty of loyalty and duty of care. Starting with subsection A, a member of an LLC owes the LLC and subject to section 801. 801 is a direct action by a member against a member. The other members of duty of loyalty. In other words, it carves out a member's ability to have legal action against another member under section 801. Subsection B, again, fiduciary duty of loyalty of a member managed LLC includes these duties. And again, these are consistent with ORS 63-145. Subsection B literally mirrors section 2A of 63-155. Talking about basically improper benefit in the conduct of winding up the company for use by the member of the company's property or the appropriation of a company opportunity. Subsection 2 there mirrors section 2B from our existing statute. Subsection 3 mirrors section 2C of the statute, and not competing with the company before the dissolution of the company. So in other words, as it's ongoing. Subsection 3, I'm kind of flying through these, is the duty of care, which again mirrors the statute with the exception of when it says the duty of care of a member managed LLC and the conduct or winding up of the company's activity is to refrain from engaging in grossly negligent or reckless conduct, willful or intentional misconduct, or knowing violation of law. Willful is not in ORS 63-155. I don't have any concerns with it. I didn't know if litigator had issues with the inclusion of willful in that section.
Aurelia, any concerns?
No, I mean, it's an or. I think you can get them whether it's willful or intentional. I don't think it's a big issue.
Teresa is the only other litigator in the.
You know, I don't feel particularly strongly. I'm not. Willful often means that you intend. There's a lot of discussion in the bankruptcy world about what willful means in terms of dischargeability and whether you intend the consequences of your action or you just intend the action to happen. So I think there is meaning to it, but I think it's probably better the way Rolka wrote it than not. So I'm inclined to go with the Rolka version.
Kyle, you have anything else? Sorry, I didn't mean to exclude you as a litigator.
No, I think it's fine.
Okay. Good.
Sure. Going down to subsection D, mirrors subsection 4 of the statute. Members shall discharge the duties and obligations, using good faith and fair dealing. Absolutely reasonable to keep that. Subsection E, a member does not violate duty or obligation under this act solely because the member's conduct furthers the member's own interest. Again, consistent with subsection 5 of our act. The next section, subsection F, does differ from our current ORS. All the members of a member managed LLC or manager managed LLC may authorize or ratify, after full disclosure of all material facts, a specific act or transaction that would otherwise violate the duty. And our current statute actually is more specific to, instead of providing a broad ability to ratify any act, it's specific to lending money or transacting business, so long as so long as it's one fair, authorized by the operating agreement, or and then authorized or ratified by a majority of the disinterested members. So our current statute goes further in terms of what is required to ratify.
Cliff, can I just get the ORS for my notes real quick?
Yeah, 63-155, and I'm specifically looking at subsection 6 of that statute.
Cliff, it looks like in the Oregon statute that it's a majority. If you go down to that 6C, majority of the disinterested members, and in the ROLCA, it looks like all of the members may authorize it. So it's kind of, it's both more flexible and less flexible, if you see what I mean.
Absolutely, yep, I do. So it's requiring unanimous decisions. I'm not a fan of unanimous consent on these. I actually like the ORS 63-155 flexibility, or I guess categorization of majority of the disinterested members.
Does that raise an issue in how you define disinterested members?
I think that's pretty well settled in case law, and you'd have to look there. And I guess one of the problems you often do run into is that there are no disinterested members in certain transactions. For example, if everybody is loaning money to the company and everybody's been interested, and I've had that situation pop up. So for that reason, it may be that ROLCA goes to all of the members. Again, is it a default rule?
For what it's worth, the commentary states that the operating agreement can vary this, provide additional or different methods of authorization or ratification, subject to Section 105.
And I often do see that varied in operating agreements. So I guess to that point, are we fine with ROLCA, or is there an interest to make it consistent with our existing ORS?
I'm going to vote for ROLCA on this one.
Me too.
Yeah, I think so.
I would stay with ROLCA here.
Good.
I would stay with ROLCA as well.
Very good.
Great. Okay.
Cliff, I have the same instinct as you. I think unanimous member consent is often difficult to obtain as a practical matter. So I don't like it as a practicing lawyer, but under both existing law and ROLCA, you can vary the rules, and I'll just plan accordingly.
And we'll all plan to change our operating agreement so we don't require unanimous consent on this point. So G does kind of pick up part of ORS 6355 in terms of, is a defense to a claim under B2 that the transaction was fair to the limited liability company, which is the first subsection of 6 in the statute. I do like that. H, if permitted under F, which is the unanimous consent, or I6 below, that a member enters into a transaction that would otherwise be prohibited. The member's rights arising from the transaction are the same as those of a person that is not a member. In other words, it's not, the way I've read that is it's not providing that person with the protections of a member. So I'm curious as to people's thoughts on H.
My thought is I don't understand it. But
there's a good discussion of H actually in the commentary, Roberta, on page 114.
Talks about that it's a reformulation that makes clear that the provision has nothing to do with fiduciary duty pertaining to conflicts of interest.
Yeah, and clarifies that you can vary it by the operating agreement as well to the extent that you want to do so.
But to Roberta, to your point, I still have difficulty understanding that section.
Okay, I took a look at this and I think that I understand what they're trying to get at, which is in order of priority of payment, when you are looking at not enough money to pay everybody, you would ordinarily pay third-party creditors before you would pay shareholder loans if the shareholder loans were in violation of these provisions. In other words, if this was a self-dealing transaction of some kind under B2, and the shareholder or the member loaned money to the LLC, then ordinarily it would be paid after the third-party creditors, because it loaned money as an adverse party, right? It's credit. It can't be both creditor and a member at the same time and not be adverse to the interests of the company, because company's interests are paying its bills. So what this is saying is that instead of paying the third-party creditors before you pay the member loan, that you pay them pari passu. I think that's all this is really trying to get at.
Yeah, and I see that in the commentary, but I think where I got lost was in the cross references to F and to I6. So is this saying that the members whose actions have not been ratified are on the same level as other creditors? Or are they saying that the members whose actions have been ratified are on the same level?
I think it's saying that you can't do this transaction. I mean, normally you can't be in an adverse position to the company, right? So under B2, you can't deal as an adverse party. So you can't be both the borrower and the creditor. But if you either have become the borrower and the creditor because everybody's agreed to it under F, or because for whatever reason you don't have a duty under I6, and I haven't thought about exactly what that means, but if you've done it under those circumstances, then you get to participate like you're a real third-party creditor. And I suppose by implication, if you haven't done it under those circumstances, then you are going to be subordinated. And this really applies in liquidations that are outside of bankruptcy, because inside of bankruptcy, Section 510C of the Bankruptcy Code is going to subordinate the owner debt anyway. Right. So I'm not sure how important in the real world this is going to be when a company is really truly insolvent and ends up in a bankruptcy case. But if it's dissolving and winding up outside of bankruptcy, it might matter. Or if you're in a receivership in state court or something.
Okay, so Teresa, if I can understand this correctly, so ordinarily these actions would be a conflict of interest. However, they're not a conflict of interest because they've been ratified or there's no fiduciary duty for whatever reason. And therefore, you are in both positions, and members in both positions, both adverse and a member. And so therefore, because they're adverse, but that's okay because everybody says it's okay that all the other members say it's okay. Therefore,
I think it has to do to a certain extent too with respecting the form of the transaction, because it's that difference between debt and equity, right?
Right, exactly.
People are allowed to choose how they deal with the company as long as everybody agrees.
Right. And so that means it's real debt, basically.
I think that's what this is really getting at. You get to treat it like real debt and not like it gets paid only after all the third-party creditors have been paid, which effectively is what equity is. I mean, you can look at it as subordinated debt that gets paid above equity, but after real third-party creditors. I don't know that they're getting that sophisticated here.
The other thing I'd point out is this is really an internal section. I don't think this section controls the rights of third-party creditors. So I think there's other facets of the both bankruptcy and non-bankruptcy law that's going to control how third-party rights come into the mix. This is just, I read this as strictly the relations between member and or manager and the company, and how the transaction is viewed internally in the company. So I think it's important to remember what this provision is really about.
Right, because the bankruptcy code is always going to trump, what the state law, here's what we think the debt is relationship, so.
Yeah.
You have a copy of the bankruptcy code at home, Teresa?
Yeah, I went and picked it up yesterday because when I went to pick up my notebook, because I thought that it would be useful to have. Yeah, equitable subordination is going to be under 510 of the bankruptcy code.
Roberta, does that make sense then?
Yes, it makes sense. And I was just going to say thank you all for your explanations. And I guess now that it's explained, I think we should stick with ROLCA.
Yeah. Anybody have any objections to sticking with ROLCA? Okay, so let's move on to I, and then after I, let's take a 5-minute break. Allow people to go get water and such.
All right. So I, similar to what we have in 63-155, where it is providing that managers are held to the same standards of conduct for members in the cited in other sections of that statute. And here they're saying, again, ABC and G, they leave off D, which is the good faith, but catch it in section 6, subsection 6 of I below. And D, notice that E is the violating the act solely by act or conduct that furthers the member's own interest is excluded from that section. And it's specifically in I, I subsection 4 says that that section only applies to members, such that managers under this rule can act in their own interest and engage in conduct that furthers that member's own interest. It's specifically carved out. So I thought that was interesting. And then the power to ratify also only applies to members. So if there is an act of a manager, the members cannot ratify it for subsection F, and that's set forth in I5 and carved out even in subsection I1. It's just not included. Subsection 2, literally stating that the duty under B3, which is competing, will continue until winding up of the company. D is the good faith and fair dealing, which applies to both members and managers. And I don't have a concern with that. Subsection E is applying to members only, which you already covered. Actually, from that perspective, I think I've addressed again, I think the bigger piece that I was interested in was wondering why ratification only applied to members under I5. And I did not have an answer to that. And all the commentary says is the power to ratify belongs to the entity's owners.
Well, I think what it means is that members are the only people who can do the ratification, because if you read F, it says members of a member manager LLC can ratify, and members of a manager LLC can ratify anything that happens. I think what they're saying is that the managers can't ratify their own conduct without the members agreeing to it. And to me, that makes a lot of sense.
Well, this may answer my question as well, which is that E says applies only to members, but does that mean it also applies to member managers? Is that what the implication of that?
Well, I think if you wear both hats, you are a manager, and the managers by themselves obviously here can't ratify their own actions. I mean, you go back to F, and it's really all of the members authorizing or ratifying the actual manager.
And I understand that, but I was looking at E. Well, it's subsection 4, I4, which says subsection E applies only to members, and E is that a member. And I think I'm going to assume that applies to member managers as well. But it wasn't totally clear to me what they mean.
I see your point.
Yeah, that was my earlier point, in that it's, to me, it seems like a manager can act in his own interest in conducting business with the LLC, which I didn't understand. I think I'm missing something there.
I think the commentary under subsection E is helpful.
I think so.
Page 113.
Yeah, I think so. I think that's right. Because they're looking, it depends on what hat they're wearing. Are they wearing their manager hat, or are they wearing their member hat? And if you're a member manager, if you're wearing your member hat, then
yeah.
Then you
I think in the context of a manager-managed LLC, that first hat, as it applies only to a member, probably doesn't have very much significance in terms of their actual duties. The member's actual duties.
Yeah. Are you looking at that top of page 114, Michael?
The bottom of 113 through
Bottom of 113.
Yeah.
Yeah, I think that's pretty clear. Thank you.
Yeah, but let's make sure we incorporate this, Andy. Okay. Any additional discussion on sub I? All right, let's take a 5-minute break. Go get water, do whatever, and come back at 10:56. Okay.
I'm going to have to drop off. I've got an 11 o'clock.
Okay. Thank you, Kyle.
Thank you
Thanks,
all.
Kyle.
And what, in terms of coming back, what are we coming back to then?
Are we not going to go on to 410? Who's doing 410?
I think 410 was part of the other sections 4, which was originally given to Roberta and Kathy, but I know that wasn't necessarily prepared for today. Is that right, Cliff?
That was my understanding.
Okay, so for section 4, just looking at the schedule. Oh, because I have
back to part of Article 3 when we were done.
That was another thought. I mean, I did. It wasn't, the last meeting ended pretty quickly for whatever reason, and the notes I took were that we were going to start on 4, but there's definitely an opportunity to go back to 3.
Okay, so let's take a break and then we'll talk about where we're going. And then probably not too much more substantive discussion, so Kyle, we'll put this in the notes. So you can drop off if you need to, and then we'll circle back because I want to make sure we've got a good roadmap so people can prepare.
Yeah.
Cliff, have we gone through everything that you've prepared for today?
Yeah, that was it. That actually concludes the sections that Mohsen and I were responsible for.
Okay, so let's circle back after a 5-minute break. Okay.
Great. I'm pausing the recording.
Okay, good to go?
Yep.
Okay. So I had in my notes that Cliff and you and Mohsen were going to do 410 as well. So that's not the case. Because that's the last section. So 409 and 410 is the rights to information.
Okay, I think that if that's the case, let me go back. That may have been one. I'm just going back and looking, and I don't know that that's true, but maybe one that was.
It's that last section in Article 4. Member, manager, and persons dissociated. Roberta, did you have that on your to-do list?
Oh, no, actually take that back. I'm sorry. Yeah, Mohsen was going to take that.
Oh, okay.
I think what's on our to-do list is 401 through 406 for me.
Okay, and then where did we leave Article 3? Did we need to circle back to Article 3?
There were some questions that need to be answered. I'm not certain if we have any sections, but there's like overall, I actually think, Valerie, we should, at one point, we should actually have a meeting just to, because I probably have 20 or 30 different things to kind of follow back up throughout the notes. Maybe we want to actually reserve a meeting for that.
Yeah, probably you and I should have an offline meeting just to make sure we have the same questions.
Okay.
Sandy, and then we'll circle back with the group. Okay, so, because I have notes all the way through Article 3.
Yeah, I do too.
So for purposes of next time, and I think this format actually worked okay. So great job, everyone. So we'll send out a scheduling thing. Who knows where we'll be next month? I mean, hopefully back in the office.
Yeah, and I just have a comment, and which is that I have a virtual conference on May 14th and 15th.
Okay.
So, but other than that, I think I'm
we'll talk
I'm
about
good.
scheduling next. Okay, Roberta.
Sure.
So I think for next time, we'll make sure that Mosen's available because we do need to cover 410. So we'll do 410 next time. And then Roberta and Kathy will do 401 through 406. Yes? 5. And then I have Teresa. Well, so actually we'll do that. And then in the meantime, Sandy and I will come up with a list of sort of follow-on questions that we think we need to address. And so the last part of the next meeting will be going over those follow-on questions.
Good.
And then Teresa, I've got you at Article 5, probably for the meeting after that, if that makes sense. So for the June meeting.
Yeah, that does make sense to me. I had Article 5 on my list, and you're right, it doesn't sound like we'll get to it next time, but
yeah,
I'll be ready for the June meeting for that.
Good. Yeah, because I don't think it's going to take the entire time next time to go through the first part of Article 4, but I do want to make sure that we're at a good point where we can address some of those questions that we've raised. Okay. Okay, scheduling. So everybody's got their calendars. Let's see, week view, month view. Well, it's very difficult to know right now where we're going to be in May. I had myself going on vacation, which is not going to happen now. That's sad. Okay, so Roberta, you're out the 14th and the 15th.
Yeah, and I have a dentist appointment on the 6th, and who knows whether that'll happen. But
well, for now, what does that week of the 11th look like for everybody?
I'll be home with the kids.
I'm totally available.
Yeah, I'm pretty much available. Everything's been canceled.
Yeah.
I'm not available on the 13th or 14th.
Okay.
Okay.
I have a board meeting the afternoon of the 11th.
Okay, what does the morning of the 12th look like for everybody? Tuesday the 12th?
Good.
It's fine, assuming that my volunteer work doesn't start up again at Food for Lane County, which I don't think it will. So, and anyway, I can skip out for one anyway.
Okay, yeah, because you're going to be critical to the next one, so I want to make sure.
And I actually think Catherine is on too. I think that she's
on the
the
phone.
She's the 503 number that's on the phone.
Yeah,
so.
she is.
Can we unmute Kathy and make sure she's okay with that? Sandy?
Yeah, I can, as long as she's okay with that. Kathy, are you there?
Yes, I'm here.
Did you hear our discussion on next meeting scheduling?
Yes, that works for me.
Okay,
Okay,
so
perfect.
we'll tentatively plan for May 12th, if the world doesn't end between now and May 12th. And then for June, I'm not going to France. So what is the week of the 8th, or what does the 9th look like for everybody?
I'm available.
Looks good.
Okay.
Yeah.
I'm not.
You're not?
Oh.
Nope. I have a tribal thing.
You have
Okay.
a tribal thing.
What about the 10th?
10th works for me.
Yeah.
Okay.
I'm fine with the 10th. I have a meeting that day, but it's not till the evening, so.
That works.
Oh, that's right. You don't do the business law EC meetings anymore, which is also on the 10th. But let's plan on the 10th then for June.
Okay.
Okay.
So I'll send those out, Valerie.
Please. Good. Well, thank you all. I really appreciate your participating. Thank you so much, Cliff, for doing such a great job leading our discussion.
Thank you.
Optimistically, we had some discussions with Legislative Council last time and gave an update to the Full Laws Commission on how well that went. And we'd been planning on following up with the staff at Senate Judiciary on, well, I'd been planning on following up with staff at Senate Judiciary just to make sure we're starting to get our ducks in a row, and that we know what format they need everything in, but that sort of got tabled. So maybe we'll have an update on that when we reconvene. But
yeah, Valerie, I'm in discussion with those staff now. I mean, they're just so laser focused on anything for the crisis.
no,
I think we need to wait for a while.
Yeah, I don't want to bother them until we're past this. So anyhow, well, thank you all really much. I really appreciate all your time. And again, thank you so much, Cliff, and good luck.
Thank you.
Stay healthy. It's good social
Thanks,
distancing.
Valerie. Thanks, Cliff.
I really appreciate everybody. Thank you so much.
Stay healthy, all.
Take care. Bye.
Bye. Thank you.